three of those men, Oriol Junqueras, the Vice President of Catalonia and its Minister of Finance, Jordi Cuixart, a respected civil society leader, and Jordi Sànchez, a member of the Catalan Parliament and President of the Catalan National Assembly. Each of them has been imprisoned since autumn of last year, in October and November, and their detention and continued imprisonment is an affront to human rights, designed to prevent them from performing their role as political representatives of the Catalan people. Today, we have lodged on their behalf an application to the United Nations Working Group on Arbitrary Detention. Their imprisonment by Spain clearly falls foul of international law, and we ask the UN to make that declaration and then to use all of the resources at its disposal to secure the release of these men. In particular, our application sets out that the imprisonment of Mr. Junqueras, Mr. Cuixart, and Mr. Sànchez violates their rights to freedom of association and freedom of expression, their rights to political opinion and participation in public life, and discriminates against them because of their advocacy for the rights of the Catalan people to self-determination. The proceedings against them have also failed in a number of respects to meet international fair trial standards, and as those familiar with the situation will know, over 100 academic Spanish legal experts have gone on record as confirming that the charges brought against them are unsustainable in the light of what has happened, since there was no element of violence against in the allegations against them. The charges are purely political, and in short, this is a classic case of arbitrary political detention. I want to emphasize that this case does not, and I repeat, not ask the United Nations to adjudicate on the issue of Catalan independence. Rather, it seeks the UN's reaffirmation that governments cannot repress political dissent through arbitrary detention of opponents. Spain must release these men. The actions of the Spanish government set a dangerous precedent for the right to peaceful protest and political opposition around the world, and we ask, therefore, for the UN to strongly reiterate that governments cannot use empty criminal charges to quell political opposition. I'll now ask my colleague Rachel Landon to say a few words.
I'll say a few words in Spanish just to get the situation in Barcelona clear. España ha encarcelado a nuestros clientes, a los tres que defendemos hoy, para impedir que ejercen alguna actividad política que siempre han ejercido antes de manera pacífica. Señor Sánchez y Junqueras han sido elegidos como diputados y no pueden escoger sus puestos. Las autoridades españolas usan de modos dictatoriales, encarcelando a oponentes políticos y negando su liberación para que abandonen sus convicciones y sus funciones políticas, lo que constituye, y lo que hemos podido analizar, como de verdad una inadmisible violación de sus derechos fundamentales.
Thank you very much. We'll take some questions if there are any, either from the Spanish link or from those in the room. Could you please identify yourself?
Hi there, good morning.
So the process within the working group is a flexible one in terms of timing, and obviously the more urgent, pressing and politically significant a case is, the greater is the expedition with which it's likely to be dealt with. We are optimistic that the working group will take steps swiftly to refer the application to the Spanish government for its response, and will, having taken comments on all sides, come to a decision as quickly as possible. As far as the implications of the decision are concerned, it begins with the declaration from the working group that the detentions are arbitrary political detentions. And I just pause at that point and say, imagine for a moment that the United Kingdom imprisoned the leaders of the Scottish National Party for advocating the independence of Scotland. That is the situation that we're here confronted with. And we are optimistic, therefore, that there will be a favourable decision from the working group. That becomes the start of a process rather than its end. And we expect the United Nations then to take all appropriate measures to put pressure on Spain to ensure that these individuals are not detained for their political advocacy of a non-violent kind. And we hope that the Spanish authorities, including its courts, will pay due respect to the decision of the working group when it comes. It's not, as I think probably many of you are aware, a binding decision in the legal system of Spain, but it's an important step to bring Spain before the bar at the international community level in order to get a declaration which makes clear that this type of political oppression is something which belongs to a long bygone era of Spanish history.
How long will it take to have an answer from the working group?
It's going to depend on the urgency with which the working group decides to pursue the matter and the speed with which the Spanish authorities respond. I mean, obviously it's not going to be this week, but we are hopeful that it's not a process that is likely to drag on for many months.
And first you, and then we go to Barcelona, okay?
Yes, for many years Spain was considered a model of democracy and of transition from dictature to democracy. But the behavior of the police and the Spanish judges and government has posed some serious questions. What does it say, in your opinion, about the state of Spanish democracy and the independence of its judicial system, and how has it affected the image of Spain in the legal community?
I can answer that question very shortly. It is a cornerstone of political democracy as it is understood in the international community in modern times, that there should be scope for plurality of political opinion and opportunities for the advocacy of political change, even if it's unpopular with the majority government, even if it doesn't command the majority opinion of the people, although, as we know, that is not the position here. To use the machinery of the state so as coercively to force people into jail and only to release them or to abandon criminal proceedings against them if they abdicate their political beliefs has a chilling effect on the plurality of democracy. It has a chilling effect on the ability of democracy to function properly, and as I say, it belongs to a bygone era in Spain's history that many of us thought was long left behind.
Okay, let me see if there is any question in Barcelona. Okay, I have to check one moment the volume. Okay, so sorry for. Okay, so now hola nois des de Barcelona. Si teniu alguna pregunta.
Una mica de... Hola, bon dia. Oriol Soler del Diop.es. La meva pregunta és exactament l'admissió a tràmit és automàtica o ho ha d'estudiar aquest comitè de la ONU i si aquest comitè ha de demanar algun tipus de documentació, ja la porteu vosaltres o l'ha de demanar el govern espanyol o el Tribunal Suprem?
Okay, in English, the question is if this working group has to accept automatically this application or if they have to consider whether to consider the application. And secondly, the documents are those that you present or will they have to then subsequently ask for documents from different parties?
The short answer, of course, is that like any judicial tribunal, the working group needs to decide whether there is sufficient evidence and sufficient material here to raise a case suggesting that Spain has acted in an arbitrary fashion in affecting these detentions. We are strongly optimistic that they will come to the conclusion that there is, and that the next step will be to refer the application to the Spanish government for its answer. Documents, of course, have been filed, a substantial quantity of them, with the application, and further documentation no doubt will be required. But you really don't need a vast amount of documentation to see the point that lies at the heart of this application, which is that if you go around imprisoning those who advocate for political change, you are undermining the foundations of democracy. And fortunately, we have the United Nations Working Group on Arbitrary Detention as a long-stop protection to ensure that states don't misuse the machinery of state power in order to force political opponents to abandon their cause because they are at risk of being imprisoned for exercising the rights to freedom of speech and freedom of expression.
Hi ha alguna pregunta més des de Barcelona?
Sí.
Sí. Wait a moment, okay? Hem estat triant aquí.
Si ho tinc ben entès... Ei, se sent?
Sí.
Molt bé. Si ho tinc ben entès, aquest organisme ha fixat posició sobre la vulneració de drets humans a països com Venezuela, Ruanda o l'Iran. Espanya està en aquest grup de països, doncs?
As I understand, this working group has presented cases in countries like Venezuela, Rwanda and Iran. Does that mean that Spain now finds itself in this sort of company?
Well, the working group has dealt with cases against a wide variety of states, including the United Kingdom. Certainly, if the application is successful, it is a serious blight on Spain's claim to democracy. And we are confident that this application reflects that Spain is allowing a backslide from genuine commitment to democratic principles.
Okay, if you don't mind, we finish in Barcelona because it's easier for us. Hi ha alguna cosa més a Barcelona?
Sí.
D'acord.
No sé si ens podria dir que vostè porta la causa ha presentat el recurs per Junqueras, Sànchez i Cuixart, també hi ha Joaquim Forn, exconseller d'Interior a la presó, si ell no ha sigut una decisió personal, i segons si normalment quant de temps porta des que es presenta el recurs, es pronuncia el grup de treball i si el govern donés tota la informació.
Okay, two questions. Firstly, that in this case you're representing 3 of the imprisoned men. You're not representing Joaquim Forn, and is that because of his personal preferences or what are the reasons for that? And secondly, if you can explain more about the timescale, that from when you present the case to how long do we expect it before we have some sort of decision?
The case of Mr. Forn illustrates many of the problems that we have just outlined. It is an incredibly difficult decision for any individual who has been locked up in jail for their political beliefs, what steps they wish to take in relation to securing their release. It's been widely reported that Mr. Fawn has made statements abandoning his political position and abandoning his position as a deputy in the new parliament. The chilling effect of detention is being played out as we speak. And so, of course, it is in the end a personal decision for him where he draws the line, but the three clients that we represent remain committed to their cause, above all to the cause of free speech. As far as timing is concerned, I've been pressed a number of times on this, and I've said the same thing, which is the timing will depend very much on the priorities of the working group. But if you want me to translate that, it translates into weeks or months rather than years.
Teniu alguna cosa més a Barcelona? No? Teniu alguna cosa?
No.
D'acord, doncs continuem aquí, d'acord? Okay.
Francisco from the Times. If you get the declaration, assuming you do, obviously that's a massive international embarrassment for Spain. But do they actually have to take any notice? And what further sanctions can be brought to bear?
Yes, I mean, that's an entirely legitimate question. And as with any major piece of international litigation, there is more to the strategy that's being pursued on behalf of the Catalan political leadership in the international sphere than just this application. This is the first salvo, and there will be further steps to come. Of course, in due course, when proceedings have concluded in Spain, there is recourse to the European Court of Human Rights, which is binding on the Spanish authorities. But we're very much hoping that a clear statement from the United Nations, backed not only by the working group but by other aspects of the Office of the High Commissioner for Human Rights and the Special Procedures of the United Nations, will bring to bear sufficient political pressure upon Spain, and indeed that its judicial authorities will take account of what is a judicial decision by the working group in order to exercise the powers that are absolutely available to them to release these men and allow them to continue with their political activities, peaceful as they are. And I emphasise, these are non-violent political activities of a kind that would be tolerated in any modern democracy, apart, it seems, from Spain.
Allà al país? Just here.
Two short questions. Are you aware that these political ideas that your three clients have been defended and are defended legally and peacefully during years and also in the present, and that the charges they face are typified in the law of a European democracy legal system? And the second question will be: do you think it's accurate to say Catalonia takes Spain to the United Nations, as you say in the press release?
Let me take the second question first. That's a short form. It's obviously three individuals who are taking their case to the United Nations, but they are three highly significant individuals for the Catalonian independence movement, including the vice president.
But not Catalonia, not actually.
Well, Catalonia obviously doesn't at current time have standing to bring one state to. It's not recognised as a state, but they are. It's the Catalonian cause and the suppression of the Catalonian cause by the actions of the Spanish authorities, which is being brought before the working group. Can I ask my colleague just to take the first question, which I wasn't sure perhaps you'd like to repeat it in Spanish.
The question was if you are aware that these political ideas that your three clients defend are being defended and have been defended in Spain many years peacefully and with no consequence, and are you aware that the charges they face are typified in a democratic legal system?
Your questions, in fact, both sides are very linked, because in fact for years effectively there've been a cause to get the independence. For years there have been some complaints against them, in fact. in front of the jurisdiction of Catalonia, Tribunal Supremo of Barcelona, because it's the competent jurisdiction for these events. And never, for years, the courts of Catalonia accepted the crimes of sedition and rebellion that now are the cause of their imprisonment. Because they were saying, as we say, and because it's still true, that these crimes cannot be constituted because they both need violence, and there has not been any violence forever in this movement. You can criticize it, but there is no violence. And the qualifications of rebellion and sedition, and you've got law professors, you've got even judges of the Tribunal Supremo who all said that without violence these crimes cannot be constituted. And why they have qualified these events suddenly with this qualification, because these are the only crimes who could put them in jail. If it was just disobedience, they could not be in jail.
And I suppose I would add to that, it's just not true to say the crimes of rebellion and sedition, as they have been applied in this case, find echoes in other European democracies. Because...
I didn't say,
pardon?
I didn't say they find echoes in another, but they are in a legal system.
They exist.
They exist, but not as they have been applied to non-violent protests. Indeed, the opposite is true. The European Convention on Human Rights guarantees the rights to freedom of expression and political participation, which these imprisonment decisions ride roughshod over. So it's simply not true to say that Spain can find itself in common company with other European democracies. This could not happen in other countries, and if it did, it would be as illegal internationally as it is in Spain.
So you won't say that the Spanish judiciary system is
is acting unlawfully in international law.
It respects the democracy as any other European country would do?
In this respect, clearly not. It's riding roughshod over a fundamental democratic principle.
Okay, here we have another question.
Owen Beck from The Guardian. Are you making any representations on behalf of Carlos Cuixart? Because presumably when he's in Spain, he's also being imprisoned.
Obviously, he has an entirely separate legal team acting on his behalf, and the circumstances of his present position in Belgium are fairly well known, as are as is the response of Spain to abandon its initial arrest warrant for him for technical reasons which apparently were unforeseen when the application was originally made. But we're not acting for him at this point in time, and it wouldn't be appropriate for me to comment confirming or denying any aspect of his position until we know exactly what the next step in the process as far as he is concerned is. But those who are in Spain, I mean, what we do know is he removed himself from the Spanish jurisdiction. Those who stayed behind are now behind bars, and so it's those individuals on whom this application concentrates.
I was just Emily from Reuters Video. Rochelle, would you be able to say in Spanish for our Spanish clients what you expect the next step? I know it's going to be in English, but if you wouldn't mind just saying in Spanish whatever.
On the steps of this communication. Okay. Hemos hecho la aplicación al grupo de trabajo para que estudie lo que hemos constatado de violaciones de los derechos de los 3 encarcelados. Esta aplicación va a tardar semanas o meses, y lo que esperamos es que, y somos optimistas, el grupo de trabajo realice que hay violaciones de los derechos de manifestación, de los derechos para tener un juicio que sea legítimo y respetable, y esperamos que en algunos meses pueda constatar que España ha violado esos derechos fundamentales. Las decisiones del grupo de trabajo no son una obligación, es si España quiere someterse a su decisión, que sería un símbolo importante para nuestros clientes, ya que estamos muy optimistas y lo hemos realizado, que estos encarcelamientos de estas personas son de verdad violaciones de sus derechos fundamentales.
I have two small questions. First of all, so I understand after hearing your speech that you don't consider in any case that your clients breaks the Spanish Constitution or the Spanish law. And secondly, if you could tell us how was the process to be in contact, I mean, how was the first approach to be in contact with your clients? I don't know if you put in contact with them or they called you, or how was this approach? And I don't know if Omnium is organizing this event, but I don't know if your clients are going to pay your job in terms of private clients, or Omnium Cultural and the other organization are going to pay this process. How is in terms of logistics? Thank you.
Yes, well, the answer to your first question is a qualified no. There is nothing in the allegations that have been made against the three individuals who are in custody which meets the requirements of the offences that they have been charged with, because of the absence of violence in their conduct. Would there be other Spanish provisions applicable? The answer to that question is that the majority of Spanish criminal lawyers have taken the view that there is potentially other scope for other charges, but not imprisonable ones. In other words, the key point is that you cannot use prison, even under Spanish law and the Constitution, as the basis for suppressing non-violent political speech. I mean, it is a universal principle. It is surprising that we're having to even debate this, because it has been one recognised in relation to democracies and dictatorships all over the world for decades. And yet Spain is doing the very thing which is an affront to the right to organise, the right to expression, and the right to legitimate non-violent political movements. It's all. I mean, that is the axiom question. I mean, a democracy tolerates non-violent dissent and non-violent opposition. The suppression of non-violent political speech is simply inconsistent with international law. As far as the arrangements are concerned, obviously we were approached as a legal team, an international legal team, by a coalition of those who were involved, the individuals themselves and the organisations, and that is the way in which the legal arrangements are made. So we're acting together, the clients are acting jointly, and with, of course, the support of the Catalan community and the organisations, the non-governmental organisations that you mentioned.
Martin Benedict, Associated Press Television. A question in Spanish, if I could, please. Could you explain to Spanish viewers what is the value of this initiative if it's not binding?
En Spanish. Okay. Por ahora no tenemos, este asunto ha sido solo analizado por las Cortes españolas, y hasta que no se terminen todos los remedios nacionales no podemos ir a la Corte Europea. Entonces, ¿qué queda a esas personas encarceladas que piden que estén metidas en libertad muchísimas veces y siempre le contestan pues no, porque todavía creéis en lo que es, lo que quieren, el combate que tienen desde hace años, y lo niegan? Entonces, ¿qué queda? Pues queda este grupo de trabajo que no es binding en English, como decía, o sea, que no es obligatorio, claro, pero sería un mensaje fuerte, y es por ahora lo que queremos ya, porque estas personas no tienen tantos remedios y todas las puertas en las jurisdicciones españolas están cerradas.
Any more questions? Okay, then.
Very quick one. I think you just mentioned that. Why not the European Court of Human Rights?
Go ahead. No, please.
The short answer to that is a technical one. The short answer to that is a technical one. The European Court of Human Rights only has jurisdiction to consider applications against Spain, or indeed any other member state, when all domestic remedies have been exhausted. And so for any of the actions that have been taken against the Catalan political movement or individuals within it, all remedies need to be exhausted within the Spanish legal system before an application can be launched to the European Court of Human Rights. The Working Group on Arbitrary Detention, by its nature, is concerned with people who are locked up now, and therefore is able to act without exhaustion of all domestic remedies. And so, as I said to you earlier, this is the first salvo in what will be a significant, sustained and wide-ranging international legal campaign until the injustices have been resolved to the satisfaction of those who have been in jail.
So, okay, sorry, last question. Thank you. Take advantage of your generosity with the time. Regarding to the first part of your speech, you say that this is a question because I don't know if I understand clearly. So you compare this case to, I mean, in one sense, it's like you say that it could be the same if the British authorities put in prison the Scottish national politician who hold the referendum in Scotland.
Mm-hmm.
So you compare both situations?
Can you see a difference?
Yeah, basically the Spanish authorities didn't agree with the Catalan authorities this referendum.
Well, then just change the time scale. Look at before the referendum in Scotland. Look at the movement in Scotland for a referendum. The referendum in Scotland didn't come from nowhere. It came from a grassroots political movement led by the Scottish National Party. They lost, but that's irrelevant. If the United Kingdom was to act as Spain has acted, it would have taken the leadership of the Scottish National Party and put them in jail months before the referendum had ever occurred. It's the same principle. There's no difference.
May I add that maybe you must know that the call to endorse a referendum ceased to be a crime in Spain since 2005. The call to endorse a referendum. That's important too, because we're talking about 3 people in jail, and you asked, I think, maybe your colleague before, did they break the constitution? We are not here to qualify what they did, but we are just analyzing what Spain criticized and puts them as a crime, and it doesn't not fit with the qualification, what they did concretely. And again, to call to endorse a referendum is not a crime in Spain anymore.
Okay, I have some extra questions from Barcelona.
Okay.
And Gemma, teniu alguna pregunta des de Barcelona? Sí. Molt bé, endavant.
Sí, dos preguntas. Quería saber si tienen previsto reunirse con sus clientes en prisión, con Junqueras, Sànchez y Cuixart, o si lo han hecho ya, o van a ir a la cárcel a verles. Y segunda, no me ha quedado claro cómo se ponen en contacto con ustedes, si fue algún colectivo de juristas catalanes, si fue a través de la ANC o de Unión Cultural, o si se habían interesado antes por el caso ya.
So, 2 questions. The first question is if you foresee having a meeting with your 3 clients in prison, or if you've even already met them. And the second question is, you're still not clear about how this case arrived to you, about how they got in contact with you through a group of organizations or whatever. Sometimes it's difficult to follow everything here from Barcelona.
The answer to the first question is we have not yet, the 3 of us have not yet visited the clients in jail, but they are visited by the Spanish lawyers who are also named on the application as being party to the legal team. So this is a mixed legal team which is international and Spanish. However, we understand that we have the right to visit them, and we will be doing so. As far as the arrangements are concerned, I'm not sure how much more information it's possible for me to give you. I mean, we were approached as an international legal team in order to provide legal representation at an international level and look at all of the options that are available. I've mentioned, we've discussed the working group, we've discussed the European Court of Human Rights. I think when the leadership of the Catalan movement reached the point where it was becoming clear that Spain can't put its own house in order in accordance with democratic principles, they came to the conclusion that it was necessary to turn to the international community and appeal for support in favour of their right to democratic, peaceful political expression. And therefore we were approached as lawyers who act in that field.
Okay, we're asking if we have more questions here in Barcelona. Last round. No. Okay, in Barcelona it's everything fine. Here you have last chance? No? Okay, the last one.
Following this game of comparison with Scotland, if the things that happened in October 1st in Spain with the actions of the police and then the imprisonment of the Catalan leaders had happened here in the Scottish election, the second and following them, definitely there would have been a massive social and political reaction that would have brought the Prime Minister down. Don't you think so?
It's hard to speculate. I simply don't think that this country or any other modern European democracy imprisons people purely for their beliefs. And so speculating as to how it might have played out here is probably a pointless exercise. At the end of the day, imprisoning people for their beliefs, for their political beliefs, peacefully expressed, is contrary to Spain's international commitments, and it's as simple as that.
Okay. That's all? Okay, thanks so much.
Oh yes, I'm sorry, I should add, if any of you wish to have a copy of the actual application itself, they're available as you leave at the door.
Okay, thank you so much.
Okay. Let's get out first.
She's waiting in Londres.
Rachel Lindon. ¿Quería mi nombre? Rachel Lindon.
Hi, Ben Emmerson.
Sí, publicación también se la cojo. Rachel Lindon.
Okay, yes.
Yo soy abogada en París. Y trabajo con Lindon. Lindon.